I'm going to hope you can see my slides all right. Let me see what's going on here. Okay, good. And you can hear me all right? Brilliant. Okay, let me start that again. Okay. Thanks everyone for joining. It's great to be able to participate from my home here in the UK. I hope you're all enjoying your time at the conference. So this tutorial is going to be on the topic of AI inequality. And those are both sort of quite broad terms, but I'm going to specifically talk about mostly about machine learning and equality law, and even more specifically, equality law in the European Union context. So to give you a bit of an outline, I'm going to be looking at how we can apply EU equality law to the problem of discriminatory algorithms. I'm going to talk about whether fairness measures that have been proposed in the FAIR machine learning literature map onto discrimination definitions. Then I'm going to look at whether debiasing actually helps this issue of legal compliance with equality law, and indeed are some of the debiasing measures that have been proposed actually lawful under discrimination law. Then I'm going to revisit the idea of directly discriminating algorithms. So I'll cover that a bit at the beginning, but then return to it later on to problematize it a little bit further. And then finally, reflect on what it is that we might want to do, or what we might want to get out of using equality law to pursue goals of equality, and to what extent does equality law actually help us to pursue those goals. So to start with, applying EU equality law to discriminatory algorithms. I note that I can't actually see if anyone puts their hands up or has a problem. So I'm going to periodically escape this presentation just so I can check if there's anything coming up. But I wonder if there's a way I can sort of do both. Maybe if I, it seems that as soon as I go, as soon as I maximize the screen, I lose the view of the browser. So I'm just gonna go ahead, and hopefully that's all right. So I will stop at the end for questions. So don't worry about that. Is that all right, Kimberly?
Yeah, Reuben. What I'll do is I'll keep an eye out on the chat for you if you like.
Okay.
I can do that more easily than you.
Cool. And I think I should be able to hear you. So if you just shout, even though I can't see you. Great. All right. So yes. I'll start again. Okay. So as I said, I'm going to be focusing on EU equality law. So to begin with, I'll talk through some basics of EU equality law, and then we'll discuss how they might apply to potentially discriminatory algorithms. So in the European Union, equality law includes a few different instruments. So there's Article 21 of the EU Charter of Fundamental Rights, and this applies to the public sector and to member states of the European Union. And then for the private sector, so if you think about employers and others who have duties not to discriminate, those are dealt with through a variety of different equal treatment directives. So a directive is something that is adopted at the EU level, but then EU member states have to implement their own laws to fulfill the requirements of the directive. So in the UK, where I'm from, which used to be a member of the EU, we have something called the Equality Act, which was implemented in 2010, and that implemented the equal treatment directives at the EU level. So taking those EU treatment directives, those principles of discrimination law, and applying them to the UK statute book. Now, there are some differences between different EU member states' implementations. There are differences in case law that's been developed at the member state level, but there are broad similarities. So what EU equality law aims to do is to protect certain salient groups or salient characteristics that people might have that we want to prevent being discriminated against. So these include age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. So these are things that are protected by EU equality law. The way that those are protected is using two different types of anti-discrimination. So one is called direct discrimination. So direct discrimination occurs when an organization, let's say an employer, treats someone less favorably than another, either than another is treated or has been treated or would be treated in a comparable situation on grounds of a protected characteristic. So it has to be a comparable situation. If it's two people being dismissed, but in a different situation, that wouldn't count, and it has to be on grounds of a protected characteristic. So if one's dismissed, if they're dismissed for reasons other than one of those protected characteristics I mentioned before, age, gender, race, etc., then it wouldn't be direct discrimination. And there's also indirect discrimination. So this is where there's a situation where a decision maker has a provision or a criterion or a practice, so a test that they apply to applicants for a position in a job, or a criterion, a rule that is applied to everybody, which doesn't actually mention or feature explicitly the protected characteristic. So an example would be a requirement for applicants to a job to be a certain height, and that might exclude, disproportionately exclude women who are on average not as tall as men on average. So that would be indirectly discriminatory because you're applying a provision which doesn't mention gender, but in fact does end up putting women at a particular disadvantage compared with men. Now, there's a difference in terms of the potential justification of these different types of discrimination. So direct discrimination, apart from a very small number of circumstances, can't be justified. So you can't turn around and say, yes, we are doing direct discrimination, but we have a good reason for it. That's not available if it's direct discrimination. On the other hand, if you are engaging in indirect discrimination, so for instance, the height requirement for the job, then it's open to you as the decision maker to justify that provision, criterion, or practice if you can argue that it's a proportionate means of achieving a legitimate aim. So the means being proportionate would say, well, yes, let's say your legitimate aim is that people on this particular job have to reach items at a certain height in a warehouse, for instance, and so maybe it's legitimate for you to need to seek to do that. And one way of achieving that is by having a height restriction or a minimum height requirement, and that might be a proportionate means of achieving that, even though it does have this unfortunate effect of indirectly discriminating against women. So that's the difference between direct and indirect discrimination. Now, how do we apply these to algorithms? So let's take an example, actually quite an old example. You'll see this is dated from the 5th of March, 1988. This is an example from a medical school in the UK, which was spending a lot of time every summer assessing applications from students who wanted to study at this medical school. And so someone working at the medical school decided to use a computer to try and automate an initial filtering step. So as applications came in, rather than a human looking through every single one of them, this computer system would filter out candidates who were statistically unlikely to succeed according to the records that they had. Now, this statistical model actually used some input variables which included non-Caucasian and female. So these were input variables that were gender and race were used as variables in this regression model. And so based on previous application decisions, the model had picked up on the pattern that applicants who are non-Caucasian and female were less likely to be accepted onto the medical school program. And so the computer program replicated this bias. So this is a kind of interesting early example of a discriminatory algorithm. And in fact, the UK Commission for Racial Equality, which was the race equality regulator at the time, looked into this case and found that this was considered direct discrimination on the grounds of race and sex. So in this case, people were being treated less favorably on the grounds of being non-Caucasian or being female. So that would be an example of an algorithm that is directly discriminating because it's using the protected characteristic to make a decision, and it's treating people of a certain protected characteristic less favorably as a result. To use a more recent example, this is the Amazon hiring algorithm. This was covered in the press some years ago. Apparently, some engineers at Amazon had built a model that was going to be used, again, to screen applications, in this case for software engineering positions. And what they found was that this model seemed to be penalizing applications containing the word women's. So people whose CVs said, captain of the women's softball team. It was downgrading graduates of colleges that were all women colleges. And it was favoring verbs which were more frequently used by men. Now, this algorithm didn't, unlike the previous example, this didn't have access to the protected characteristics of gender, but it nonetheless picked up from natural language processing of the applications. It picked up the correlations between gender and these features. So this would be, as I'll explain a bit later, this would be typically understood as an example of indirect discrimination. And then a third example is gender shades. This was a project by Joy Buamwini and Timnit Gebru. It was a paper at FACT in 2018. They found that commercial facial recognition tools had much higher error rates for darker skinned females. So darker skinned women were more likely to be misclassified or to be to fail to be recognized as themselves when these facial recognition models were being applied. So these are both examples of what we might consider to be indirectly discriminating algorithms. So we could imagine we could apply this idea of an apparently neutral provision criterion or practice to the algorithm. So rather than being a policy that's written down on paper or a rule that is deployed by a decision maker in a hiring process, the algorithm itself is the provision or the criterion or the practice. And it seems to be in both cases putting people with a protected characteristic at a particular disadvantage compared to other people. So in the hiring algorithm case, we can see that's women are being put at a disadvantage. In the FRT case, we can see that Black women are being put at a particular disadvantage compared with other groups. Now, as I said, indirect discrimination, the decision maker has the possibility to argue that they are pursuing this as a proportionate means of achieving a legitimate aim. So, for instance, the employer might say, well, yes, our hiring algorithm does seem to be favoring men, but it's the best algorithm we've got, and it's legitimate for us to seek the best software engineers. Whether that justification would actually work, I doubt it, but it's open to them to argue that case. One of the things that we've been working on in this FAIR machine learning community for many years is the development of different metrics or measures to define different aspects of fairness. So one of the natural questions you might have is whether these fairness measures actually map onto the definitions of discrimination that I've just told you about in EU law. And so to run you through some of the broad families of fairness measures that are typically talked about in the literature, So anti-classification, this measure just says that an algorithm or a machine learning model is fair if the sensitive attributes, so in the attributes like race, gender, and so on, if those are not used as inputs to the decision. So those would be, in the EU discrimination law terminology, those would be the protected characteristics. So if those are not used as inputs to the decision, then anti-classification is satisfied. Independence measures basically say that the decisions that you make, so these are probably going to be decisions that are based on predictions or classifications. So invite this person to interview, predict that they're going to default on their loan and therefore don't give them the loan. These decisions should be independent of the sensitive attributes or the protected characteristics of the individuals. So it shouldn't be more like, you shouldn't have a higher rate of positive loans being granted for one protected characteristic compared to another. Separation, this just means that when you look at the error rates between groups, so this could be, we could look at false positive rates, we could look at true positive, false negative rates, or some balance between the two, or other kinds of similar metrics. Those shouldn't differ between different groups based on their protected characteristics. And then finally, there are sufficiency measures, which basically say that if you compare the two groups, the algorithm should be equally calibrated for those groups. And another way of putting that is that a score should mean the same thing regardless of the protected characteristics. So a man and men in general and women in general who are given a particular score on a recidivism risk scoring algorithm should be equally likely to recidivate. That would satisfy sufficiency. So are these fairness measures, do they correspond to the definitions of discrimination that I gave earlier? So are any of these fair ML measures or metrics, do they provide necessary and or sufficient conditions for avoiding the forms of discrimination I mentioned earlier? So let's take anti-classification to begin with. So anti-classification is, I think, necessary to avoid direct discrimination. So if the value of a protected characteristic, so e.g. Sex equals woman, has a positive or negative weight relative to another value of that characteristic, e.g. sex equals man, then that would be direct discrimination. So if you're using one of these variables as an input to your decision, then it's very likely that you're going to be directly discriminating. Then there's technically an exception, which is where you use the protected characteristic, but it doesn't. There's not a positive or negative weight relative to another value of that characteristic. But in which case, I'd see you probably wouldn't include that as a feature in your model because it's not actually providing any predictive value for you. So apart from that very unlikely exception, I think probably anti-classification is necessary to avoid direct discrimination. But it's not sufficient to avoid direct discrimination. So one reason for that is that there are cases where decision makers might actually deliberately choose a model which discriminates against a particular group because it has, for instance, it uses a feature which is a very strong proxy for that group. And so the decision maker is trying to discriminate, and if they did it directly by using the protected characteristic, then that would be direct discrimination. And if they do it surreptitiously by choosing a proxy that's a good proxy for the protected characteristic, that would also be direct discrimination. So it would not violate anti-classification technically because you're not using the protected characteristic, but it would be what Barocas and Selps call masking. So you're masking the discriminatory intent of the decision maker. but it's also insufficient to avoid indirect discrimination. So for the same reason, proxies and redundant encodings could put a protected characteristic, someone with a protected characteristic at a particular disadvantage. So that would still potentially violate indirect discrimination. What about the other measures? What about independence? So independence, I think, actually would be usually sufficient to avoid indirect discrimination, because for indirect discrimination to be the case, it has to be that people with a particular protected characteristic are put at a disadvantage because of the practice or criterion. But if you ensure independence, i.e., demographic parity or something like that, then the treatment of the individual will be independent. So the decision will be independent of the protected characteristics. So we already know that in that case, we aren't facing an example of indirect discrimination. But neither independence nor separation are necessary to avoid indirect discrimination. So it's going to really depend on a case-by-case analysis, looking at the details of the case, whether the disadvantage is sufficient to sort of meet the legal bar in that case. Also because, as I said earlier, indirect discrimination can be justified if it's a proportionate means of achieving a legitimate aim. And note also here that independence is a very strong criterion for fairness, and basically requiring equal outcomes regardless of the base rate differences that there might be in the target variable between different groups, means that it's a very strong and probably unlikely to be used. So even though it would suffice to avoid indirect discrimination, in most cases it would be too strong to actually be applied to any algorithm, because they're always going to be it's very likely that there'll be some extent of base rate differences between groups. So none of the main families of fairness measures on their own provide necessary and sufficient conditions for avoiding either direct discrimination or indirect discrimination. One thing I did say was that anti-classification is necessary for avoiding direct discrimination, but it's a very it's just one of many other necessary conditions for avoiding direct discrimination. So it's not it's helpful, but it's not that helpful. And independence might be sufficient to avoid indirect discrimination, but it's typically too strong a constraint to meaningfully apply. So I think we can conclude in agreement with Wachter and colleagues that fairness measures are primarily useful as potential indicators of discrimination, and there's no easy mapping from fairness measures to definitions of discrimination such that we could apply fairness measures and be certain that we have avoided these forms of discrimination under the EU discrimination law. So the fairness measures themselves might be useful indicators, but they're not a sure guide to these things. What about the approaches that we might use to de-bias algorithms? So once you've set your fairness measure, you can also apply various techniques to ensure that your algorithm, your ML model, meets that fairness criterion. So do these measures help in ensuring compliance with EU equality law? Well, just to recap, there are various ways that you can do this. So you can constrain your ML model to satisfy given fairness criteria in several ways, either by pre-processing, so you constrain the feature space in your data so that you know that it doesn't correspond or doesn't correlate with protected characteristics. You can constrain the way that your model learns from the data, so you can constrain the optimization process so that it meets some fairness criterion, or you can modify how the model works after you've trained it so that it satisfies a fairness criterion. Now, the first two of these are what Lipton and colleagues call disparate learning processes. So this means that you use sensitive characteristics in the training process. So in pre-processing, you use the sensitive characteristics or the protected characteristics of the individuals in the training set to constrain the feature space in accordance with the fairness criterion. Similarly, for the in-processing approach. This is distinguished from treatment disparity processes. So these would come under post-processing, because these actually require you to use the protected characteristic during deployment. When you're actually making decisions about individuals, you need to know those individuals' protected characteristics in order to change how the model behaves for those people. So this will come in, you'll see why this is relevant in a second. So the question here is, do these debiasing measures help to avoid discrimination? So do they actually help to avoid discrimination according to EU law? So one thing to bear in mind is, of course, as I mentioned before, the fairness measures that are used when we're deploying debiasing measures. So when we say we want to constrain the training data, or we want to constrain the post-processing according to some fairness definition, depending on which of those fairness definitions we choose, we might gain certain guarantees in relation to discrimination law. But as I discussed before, not many. There are not many ways that these fairness definitions directly map on, but certainly not providing both necessary and sufficient conditions for avoiding violation of discrimination law. So from that perspective, these debiasing measures are similarly limited to the extent that the fairness measures is limited. But there's a different and potentially bigger problem. So you might have noticed that post-processing actually violates one of the fairness measures, anti-classification. So anti-classification, to remind you, says that you can't use the protected characteristic as an input to the decision. But post-processing actually does require this. So post-processing and more generally treatment disparity approaches, as Lipton and colleagues call it, they actually do require you to use the protected characteristic as an input to the decision. So that already, we know that violates a fairness measure. And insofar as that fairness measure actually is a necessary criterion for avoiding direct discrimination, we can therefore conclude that post-processing approaches or treatment disparity approaches are at least at risk of violating direct discrimination or the prohibition of direct discrimination. So if we use protected characteristic as an input to a decision, this is what's sometimes called in EU law positive discrimination. And positive discrimination, apart from some exceptions, actually violates the prohibition of direct discrimination. So even if you want to use post-processing out of good intention to avoid discrimination, so you want to say, well, we're going to actually prefer people from this group because they're historically underrepresented, or we know that they face some sort of discrimination at a different point in the application process, you can't use that protected characteristic as an input to the decision. So this is distinct from positive action, which is lawful, which includes things like reaching out to an underrepresented group to encourage them to apply for a position. That's lawful. But to actually use the protected characteristic to prefer people with that characteristic, even if you're doing it to correct a historic injustice, would not be lawful under discrimination law. So the conclusion to that is that treatment disparity approaches are likely unlawful, although there are some sort of vague boundaries about the distinction between positive action and positive discrimination. So some exceptions to this, one is disability. So disability in the UK Equality Act is treated differently to all of the other protected characteristics. It's considered asymmetric, where the other protected characteristics are symmetric. So it says that it's not direct discrimination to treat people with a disability more favorably. Whereas it would be direct discrimination to treat a man or a woman more favorably because of their gender. Another exception is where there are tiebreakers. So if you have two candidates for a job and they're equally qualified, then it's permissible to favor one over the other because of protected characteristics. So if you had two equally qualified candidates, one was a man and one was a woman, and you had, as part of your commitment to positive action, you might favor the woman if women have historically been discriminated against in that particular environment. And then there are also some interesting cases which seem to suggest that positive action can include actually including a protected characteristic. So these are to some extent at odds with some of the other case law, but one case was in the UK recently went to the Supreme Court. A housing charity that served a particular religious minority was found to not be in violation of discrimination law by favouring members of that religious group in allocating social housing. So then there are cases where positive action does seem to spill over into positive discrimination, but it's still upheld as lawful by the courts. Now, the issue is none of these exceptions really seem to correspond to the treatment disparity approaches I mentioned. So, so the tiebreakers, that doesn't really, I haven't seen any work in fair machine learning that tries to implement that particular thing. Maybe you could make a case that the disability exception and this particular positive action exception could actually make use of a treatment disparity approach, but they're more exceptions rather than the rule. So to conclude this part, so some of the debiasing measures that we've seen proposed in the literature are probably unlikely to be lawful under EU discrimination law. And that's particularly troublesome because as the Lipton, Macaulay and Choldachova paper from 2018 argued, these might actually be the most effective means of achieving a given fairness criteria. So that's a particular kind of limitation of the law, unfortunately, if indeed we want to uphold those fairness criteria, that some of the most tractable ways of doing that at a technical level are potentially not allowed under the law. So I mentioned earlier that I was going to come back to this question of directly discriminating algorithms. So recall that the example I gave was one where the protected characteristic was used as an explicit feature in the statistical model that the medical school was using to filter applications. So they actually explicitly encoded race, non-Caucasian, and gender in as a feature in the model. And it was on this ground that the Commission for Racial Equality found them to be in violation of direct discrimination. But I think we can actually revisit this question of the scope of direct discrimination and find that perhaps there are a wider array of cases of algorithmic discrimination which could be classified as directly discriminating, even though they don't have that explicit use of protected characteristics. So I mentioned the case where they're explicitly encoded in the model and the case where the decision maker uses a proxy intentionally to achieve the same result, the masking case from Barocas and Selp's paper. But there are important distinctions between the US law, discrimination law, and the EU discrimination law. So in the US, the equivalent of direct discrimination is called disparate treatment. And this requires the decision maker to actually intend to discriminate. So that's why the masking example would still be disparate treatment in the US, because the decision maker actually intends to use the proxy for the protected characteristic in order to discriminate. But intention is not required for direct discrimination under EU law. And so this means that there's a wider range of ML systems in use that might constitute direct discrimination. I'm drawing here from forthcoming work with my colleagues in law, Jeremiah Adams-Prassel and Ashlyn Kelly-Lyth. The paper is called Directly Discriminatory Algorithms. I'll give you a brief overview of our argument here. So these are some distinctions between EU or EU and UK versus US law. So in the EU law context, we have direct discrimination, where one person is treated less favorably than another, has, or would have been treated in a comparable situation on grounds of protected characteristic. This doesn't need intention, and it does cover cases of implicit bias. So as I'll go on to show. And in the US context, disparate treatment, similar, person is treated differently because of their protected characteristic, but here it does require intention. And the question of whether implicit bias counts is also contested. So to go into some of the detail around the case law that establishes why intention isn't needed in the EU context, I'll take some examples from UK case law, which is what I'm more familiar with. So the JFS case from 2009 established that direct discrimination can arise in two ways. So this is in addition to a case where a decision maker explicitly says, I'm not hiring this person because they're a woman or because they're black, but where the decision is taken on the basis of a ground which is inherently racial. So this is focusing on a racial discrimination case, or because it was undertaken for a reason that was subjectively racial. So this introduces this notion of where the grounds is in the subjective bias of the decision maker. Actually, what's motivating them is a kind of racial discrimination. So there are these two categories: inherently discriminatory and subjectively discriminatory. So inherently discriminatory is where you have an exact correspondence between the people who are suffering the disadvantage and the protected characteristic. So one example of this is a case where there was a swimming pool which had a rule that said anyone who is eligible for the state pension can get into the swimming pool for free. So the idea was to encourage older people to use the swimming pool. This was found to be inherently discriminatory because the state pension age, the eligibility, the age at which somebody becomes eligible to receive the state pension in the UK is different between men and women. So by having this criterion, that meant that men between the age of 60 and 65 were suffering a disadvantage compared to women of the same age because they weren't eligible to use the swimming pool for free. So this was held to be inherently discriminatory, even though the criterion being used didn't directly reference sex. So it was found to be inherently. So we can think about this in the case of the Amazon algorithm. So in that case, the algorithm found that that there were names of women-only colleges on applications that were used by the algorithm to downgrade the applicants. Now, those women's colleges, so having gone to a women's college is not a protected characteristic in itself, but it would, we argue, count as inherently discriminatory because there is an exact correspondence between being a graduate of that college, having that college name on your CV, and being a woman. And you can imagine that as well, that there might be combinations of features which are perfect proxies for a protected characteristic. So imagine a school that was previously only for boys and then became a mixed gender school after a certain date. And imagine there's a decision criterion that says we'll accept graduates of this school, which is now a mixed school. So being a graduate of that school doesn't uniquely pick out your gender. But then it also have another feature in your decision criteria that is this person has to be born before a certain year, the year that the school became mixed sex. Now, those two criteria put together would uniquely pick out people of a certain gender. And so that would, we argue, be also inherently discriminatory because there's an exact correspondence between the intersection of those features and gender. So we think there's no difference when there are more criteria in the mix. So we could have complex combinations of variables which uniquely pick out a particular protected characteristic that would also arguably be inherently discriminatory. The other category of direct discrimination that expands the remit of direct discrimination and which also doesn't rely on intent is subjective discrimination. So this is where the decision maker might not realize that he or she is using the protected characteristic of the individual to make their selection, but that is in fact what they are doing unconsciously. And it doesn't have to be the only cause of the decision. It has to only be a significant influence on the decision. And so we can imagine that algorithms are also going to learn to replicate these implicit biases of humans, especially if they're trained on, say, previous hiring decisions by subjectively biased human decision makers. The algorithms are going to learn to replicate those same biases, and so they might end up replicating subjective discrimination of the decision makers whose decisions they have learned from. So these are two examples of where we think direct discrimination might actually apply to algorithms that include a much broader range of algorithms than previously has been acknowledged. We do think that there's a sort of uncomfortable fit, though, if we think about some of these examples. So if we think about the gender shades example, this doesn't seem to fit easily into either inherently discriminatory or subjectively discriminatory, but it certainly seems to fit into the broad idea of direct discrimination, in the sense that direct discrimination is where where similarly situated people, let's say a white man and a black woman, or a white woman and a black woman, are similarly situated with regards to the facial recognition system, but nonetheless, black women are at a higher risk of misidentification, and that's because of, I think, arguably, that's because of their protected characteristic, i.e., their race. So in that case, this seems to fit into the broad category of direct discrimination, even though it doesn't quite fit into inherent or subjective discrimination, the two examples I gave before. So it might be that we need to expand our understanding of direct discrimination to fit these kinds of examples. There are some important implications for litigation. So if we're going to litigate algorithms, if we want to, or if you're working at a company that wants to defend itself against potential litigation, if it's the case that direct discrimination can apply to these kinds of algorithms, then the defense that would otherwise be there if it was an indirect discrimination case is not available. So you can't argue that it's a proportionate means of legitimate aim if you've been found to be directly discriminating. So this actually shifts the burden of proof onto the decision maker as well. So they have to prove that they're not directly discriminating. And while in theory, these different types, the direct and indirect discrimination, are mutually exclusive, in practice, litigators can always argue in the alternative. So they can say, well, here's our case why we think it's direct discrimination, but if the judge doesn't agree, here's why we think it's also, or instead, indirect discrimination. So it'd be interesting to see how these things develop in the courts in practice. So I'm going to wrap up soon, but I just want to finish on a point that I think is important to bear in mind when we're discussing how fair machine learning can help us comply with equality law. And that's, is equality law enough? is it aiming to do the right things, and is it a fruitful way to pursue ideals of equality and justice in the context of algorithmic decision making? And I think there are good reasons to doubt that it's an adequate framing. So one of the problems with equality law in the US and in many countries around the world is that it focuses on, it's historically focused on bad actors, so decision makers who have racial animus, for instance, which obviously do exist, but are not do not account for the entirety of structural oppression in society. They tend to focus on particular decision-making contexts rather than broader societal processes that lead to inequalities between protected groups, between protected characteristic groups. And there's a danger that equality law seeks to be merely procedural, so to put in place procedural constraints on decision-making processes rather than aiming to actually create substantive equality. I think it's interesting how computer science research on fairness is actually challenging the sort of underpinnings of discrimination law. So this quote from Redia Abebe and colleagues, I think nails the point really well. Discrimination law is an incomplete mechanism to remedy historic injustices and deeply entrenched structures of oppression. So if we're looking into exposing the limits of algorithmic notions of fairness, we might also end up exposing the limits of the underlying legal notions of discrimination. So finally, I think it's important if we're thinking about applying equality law to algorithms and using algorithmic fairness methods to approach equality, we need to think carefully about what level we're pursuing equality at. So I like to use this table from Mackenzie Walk's interpretation of Eric Olin Wright's game space. So this is the game metaphor for mapping politics and class analysis, which I think could be quite useful in this context. So there are different levels at which we can try and change the world for the better. So one level is the system level. So this is about how can we change the entire system of the way society works? So that might mean changing capitalism. We could work at the institutional level. So we accept that there are different varieties of capitalism. We're still living under capitalism, but we want to change the rules of the game to make them better. And then there's the situational level, which is accepting the variety of capitalism we have now, accepting the institutions that we have now broadly as they are, but using the rules that have already been established within that setting, within that game, to try and advance the interests of particular groups. And so I think probably it's fair to say that when we're using existing equality law, we're mostly working at the situational level. And that has important impacts and it's worth pursuing, but it doesn't necessarily change things at an institutional level. And it certainly doesn't change things at a system level. So I think it's important to keep these different levels of analysis in mind when we're working on these problems, and to not assume that if we're applying the law, we're necessarily going to change things at an institutional or a system level. So that's just a caveat to what I've been saying. But I'll finish up there, and really looking forward to any questions or discussions that we might have. Thank you very much.
Thanks, Reuben. If anyone does have any questions, we've got the Q&A open in the chat. I had a question, which is, so actually just about that last slide, which is you've got, I mean, I think you're right that we're operating at that situational level with discrimination law. You know, it's about solving particular problems, particular person's been affected by a particular decision. Is there, you know, when you look at the legal framework, do you see some way we could step up to those more systemic levels via legal systems, or is that really just we have to go political? We have to, you know, vote in different people. What's your thoughts on that?
Yeah, it's a really good question. I think there are, ways that the law can change institutions for sure. The law creates institutions, and so if we're talking about reforming the law, that can change things at an institutional level. And I think there's also this concept of non-reformist reforms, which I think is Andre Gore's. The idea there is that you can make changes that are changes at an institutional level, but that make it easier for people to make more fundamental system changes. So an example of that would be breaking up the power of large corporations using, say, competition law, which might leave more space for the flourishing of other forms of ownership, other forms of production, and so on. So in the context of algorithms, you could imagine breaking up the power of the big platforms might enable decentralized platforms or cooperative platforms to emerge that might change the way that these processes work at an institutional level and maybe even at a system level.
You've got a couple of questions in the Q&A there. Can you see those? Big picture question from Cameron.
Oh, sorry, yeah, Q&A. I was in the chat. Cameron, how practically helpful do you take a focus on equality to be as opposed to a focus on an ameliorative, restorative, normative ideal, e.g. reparation? I'm sure the formalization of the relevant problem space might look different under a regime where we're interested in the ameliorative causal effects of a policy of interest. Oh, that's a really interesting question. Let me chew over that. Yeah. I think I would say that there are there's more immediate low-hanging fruit by focusing on equality law, let's say, equality law rather than equality more generally. And I think there are, at least from where I'm standing, which is a very particular position to be standing in. And whereas if I was in a different position, I would probably, potentially think that those, other, reparative, restorative approaches are more low-hanging fruit because it's relative to where you're working from. But I think, in the long term, it seems to me like working with existing law as it is only ever going to be tinkering around the edges and maybe helping some people deal with some of the big problems in terms of how they affect their lives on an individual level. But I think for long-term positive change, it needs to focus on, as you say, ideals like reparation and so on. Whether we can translate that into meaningful work in fair machine learning is an interesting question. There's a paper by Max Casey and Rediat Abebe which talks about this and looks at basically using, rather than thinking about constraints on classifiers that aim to satisfy some fairness criterion, rather look at the decision-making context and see how goods are being distributed and optimize economic equality. And that maybe is a different criterion, different constraint that you could meaningfully apply to a decision-making context where there's a machine learning model involved. And maybe that has more of a positive effect in the long term on inequality, for instance. And that might be economic inequality, but also other forms of structural oppression based on different identities and so on. I'm not sure if I've answered the question, but I appreciate it. It's a good one.
Yeah, is it a good chance to ask, or I should wait for another question?
Yeah, go ahead.
Oh, yeah, thanks. So in terms of the role played by the legislation or law compared to the one approach taken by computer scientists and in general economics and so on, so it seems like the very technical treatment is not well reflected in current law. What kind of what kind of role do you think on the other direction, from the research to the law establishment, can we, enhance or empower or improve the current legislation?
Yeah, that's a good question. I mean, I think if computer scientists working on fair ML were to bring the enormous range of different fairness criterion that have been proposed and bring them to the legal establishment and say, look, here's all these different definitions we've come up with, I think that would probably not be a productive way forward. But I think there are definitely, especially where there are examples drawn from real life deployments of ML systems, where we can very clearly show all the surprising ways in which large data sets encode structural inequalities in the real world, and use that to kind of show how existing legal frameworks are inadequate to deal with those bigger problems, and where to reveal the extent to which more procedural approaches to equality law just don't get at the big problems. I think there is a role for data scientists and ML researchers to play in that, but that really requires actually engaging with the sort of social processes that generate those distributions of different base rates between protected characteristics, and that's something that I think is ongoing, but I think there needs to be more of it in the CS community before that can be a productive conversation with the legal establishment.
Thank you very much.
You have a question there from Michael Chance in the Q&A too.
Michael, it sounds like the main difference between disparate treatment and direct discrimination is intent versus causation. How does that play out in regulating machine learning? Is it appropriate to assign intentions to machine learning algorithms to regulate them under disparate treatment? Or do they get a free pass under disparate treatment that they don't get under the... Yeah, that's a good question. So yeah, I think that's a good way of putting it. I don't understand the US law as well as I understand the EU law, and I appreciate there is a debate amongst US lawyers about the extent to which disparate treatment applies to certain algorithms. But I do think that by and large, there's the disparate treatment regime is far narrower, and therefore does allow a lot of algorithms a free pass, as you put it. So yeah, I think that's right. Whether direct discrimination is explicitly about causation, I'm not sure. I think the case law is kind of ambiguous. Sometimes the judgments will say if it's had a significant, so if the protected characteristics had a significant influence on the decision, even if it wasn't intended to, that's enough. And others will say, well, if we go down that route and we just talk about causation, then this explodes the distinction between direct and indirect discrimination, which might be true. Both those things might be true, and it might be that, as I said, we need to revisit the distinction between direct and indirect discrimination. I think that's not going to happen, practically speaking. That's not going to happen anytime soon. So I think in the meantime, it's worth using the tools we have, and that those are direct discrimination, indirect discrimination, and direct discrimination is a better tool for limiting discrimination, because it doesn't have that justification that the decision maker can make to justify the use of it that they have under indirect discrimination.
There's another one sitting at the top from Alicia Shen.
Alicia, very interesting talk. Can you give me some examples of companies' algorithms actually sued for indirect discrimination? That is a good question. There aren't many examples of this under either direct or indirect. I think there's broad agreement that indirect would be the way to go. I've seen a few cases brought under indirect discrimination, but not actually proceeded to trial. In some cases, because in cases with governments, they've proactively sort of retracted the use of the algorithm. There's a few cases in the UK like that. But yeah, mostly it seems to be acknowledged in the literature that that indirect discrimination could apply, but I haven't seen many examples of it being used. As I said, there's the example from 1988 of direct discrimination, but yeah, there aren't many examples of this in the EU context.
Now, Reuben, I see we're at time. If anyone has any burning questions, they should probably put their hands up now. But we'll come in to the chat. No, I haven't seen anything. Thank you so much. That was extremely illuminating. I feel like I've now understand things a lot better than I did before. So appreciate you spending the time today. Thanks for joining us. Thank
you, and enjoy the rest of your day. I'm going to head to bed, but I'm looking forward to catching up with the rest of the conference when I wake up.
Great.
Thanks. Cheers. Bye.